Okay, hey everybody, welcome to the stream tonight. So if you haven't heard, the HB 1927, the unlicensed carry bill, the constitutional carry bill, whatever you want to call it, has come out of the conference committee, and we have the conference committee report finally. And what I want to do is go through that because I've been seeing a lot of misinformation. Unfortunately, I haven't been able to talk a lot about the details prior to them coming out, based on conversations with various people. And so it wasn't until they published it that I wanted to talk about sort of what has happened. But before I get started on 1927, I want to say a few things. Number one, first and foremost, the most important part of all is, first of all, can y'all hear me? I hope y'all can hear me. First of all, we will have constitutional carry this year. Texas will be the 21st state. All right. And there you have it. So that's the first, the big news. I really want to make a few acknowledgements. Okay. And because there's a lot of hard work went into this session, and I wasn't really a part of that because I was gone, but Open Carry Texas was a very big part of it. I did some backroom stuff every now and then as I could, but this was just such a rough semester. I really didn't do much of anything this year. I answered some questions. I did some interviews. I made some phone calls. I talked to some representatives and senators, and tried to push this thing along. But I want to acknowledge the people who did do all the work. First and foremost, I want to thank Richard Briscoe, who was our legislative director, for him being able to do. I mean, he held the lion's share of duties for Open Carry Texas. In the past, we've been able to sort of bifurcate a lot of the things at the legislature. I'll take care of this, you go take care of that. We were able to sit in different committees at the same time because often our bills are being heard in separate places, and we just weren't able to do that this time. And most of the work was done by Richard Briscoe. And so we are where we are because of him working with Democrats and Republicans to get HB 1927 to where it is today. And he's done a lot of hard work in the background and deserves all the credit for where we are today. Who also deserves all the credit are all of you out there who for the past 7 years have been helping us push this and making it the issue that it is today. Also, a lot of great congratulations and hard work to the Gun Owners of America for what they've done this session. So Miss Malone working really hard to get, her, Rick, and even the NRA have worked really hard, but Rachel has gone out of her way. Rachel Malone with Gun Owners of America has really been on it this session as well. And I want to make sure that she is recognized for all of her hard work, because like Rick, she was there through the early morning hours. She was there, just a few hours later to get the day started all over again after a session would end. And really, Gun Owners of America really put a lot of force behind the push for constitutional carry this year. And it was really a great team up. And then also, I also want to recognize the NRA. And I will always recognize organizations and groups that have played a part. And I'll always criticize organization groups when they don't. But the NRA also made this a priority for them this session. And they stepped up to the bat. We're also very active in every single aspect of getting this bill passed, from helping to get us sponsors, to providing testimony, to providing expert witnesses, all of that. And so, and then of course you also have Lone Star Gun Rights, the National Association for Gun Rights, Texas Gun Rights, McNutt out there kicking butt as well, and Chris McNutt, excuse me. And so there were a lot of people that did a whole lot of work. This is a session where we actually got a lot accomplished. 1927 is the unlicensed carry bill, but there are several other priorities, at least from Open Carry Texas's standpoint, that 1927 filled that we don't have to worry about next time. Okay, little things that I'm going to go over as we get through this, and how 1927 didn't just fulfill our ultimate objective, which was to make the license voluntary, but also several smaller objectives that we've been trying to fight for several sessions now. And before I got started on that, I really wanted to make those acknowledgements that I really appreciate the hard work of the NRA, the Gun Owners of America, Texas Gun Rights, Lone Star Gun Rights, Open Carry Texas. There really was a lot of teamwork and tag teaming and working together behind the scenes as well as in the committees to make sure that we were all on the same page and that we were all trying to get this thing passed this year. So that is that. I want to get into this now. I want to get into the 1927. And what I'm going to do is I'm going to bring this up. It's going to be both on the side page here. Let me bring this higher so y'all can kind of see it a little bit better. And then also, let me see if I can get rid of this. Can I get rid of that? Can I? Nope. Come on, get rid of that. Scoot over. Okay, I guess that's the best we're going to get. But y'all should be able to read that. This is the committee report. This is essentially the 10 people from the House and the Senate that signed this conference committee report. And I'm going to go through it block by block, okay, so that you know exactly what. Look, if you don't want to sit through this whole video and understand the intricacies of what you can and can't do and what this bill does and does not do, because I will be honest with you, there are some areas that I'm a little concerned about. I'm not concerned about it because it's there. I'm concerned about it in the way it's written. And I know how cops are and how law enforcement are. And I just have this feeling that police think they're being given authority that they're not, just based on the way this is worded and what was and was not included in the bill. And that's my only concern. On its face, on the whole, I'm okay with this. I'm not upset about what we got for constitutional carry this year. I'm not upset at all. It's not perfect, which, we didn't expect it to be perfect because, government wants to maintain some sort of grip on our rights. It wasn't perfect, but it's definitely better than I thought it would be. And really the stuff that was added from the House is not something I believe we need to worry about. We really need to worry about as a problem. And I'll explain that as I get through it. And here, let me share this invite in the chat here. And if somebody's got StreamYard, if you've got StreamYard and you've got questions, okay, I'm not going to do a big long discussion with other people, but if you do have a question, I will bring you on for a quick question. What I will also ask is what I'll do is I'll go through this section by section, and then I'll look at the chat and see if there's anything on the chat that you guys have questions about. But other than that, I'm going to jump right into it. Oh, yeah, I guess my wife can do the questions. Yeah. So she'll let me know. And here's a piece of paper. I don't have here's a pen. If you want. Oh, we can get a phone and watch it, maybe? No? Okay, however you want to do it. My wife is going to help with the questions here, and she's going to pay attention to the chat. And so when you have a question, I guess just ask it. My wife will kind of key that into me. All right, let me make this a little bit bigger here so you can read. Can y'all read that pretty well before I completely get into it? I might just do it this way. Here we go. I'll just make it a little bit bigger there. Okay, so here's what we've got. This is the bill. One of the first things that I like about the bill, as a soon-to-be attorney, I am going to find these sections here. This section here especially is going to be very important to me because as I fight for gun rights in the future, I'm going to be able to talk about this, where it says the legislature of the state of Texas finds that the Second Amendment of the United States Constitution protects an individual right to keep and bear arms and to possess a firearm unconnected with service in the militia and to use that firearm for traditional lawful purposes such as self-defense within the home. Now, I don't understand why they had to put that. I think the reason they put that is because at this point in time, the Supreme Court has only, quote unquote, recognized a fundamental right to have a gun in the home for self-defense. Now, we all know that you have a fundamental right outside the home, but I think the reason that the legislature put this in here is because this is the current case law at this point, and that's why it's there. But this section right here is going to help a lot of attorneys in the future when we're fighting gun cases. Okay, so I'm glad that they codified this, and this is going to be codified because now I can use this as an attorney in defense of my clients right here. So, and then the second thing here, this is very important because the left has tried to say everything exactly opposite of this. People who are currently prohibited from possessing a firearm under our laws of the state and under federal law, this bill doesn't change that. It doesn't change who can and cannot possess a firearm under state law. Now, what this does do is it will change a few things in state law, but it doesn't change all of that. All right. So we move on here. Let's go to section 3. If you've got if you see a question, just let me know. Oh, when does it become law? Okay, this will become law. So here's the timeline really quick. So the timeline is this has come out of conference. It's possible that the House votes on this. As a matter of fact, it's possible that the House could be voting on this right now, the conference committee report right now, because it came out yesterday. They have to wait 24 hours before any votes can be held on it. But the House is in session right now. And so the House could very well be voting on, or is it the Senate? Anyway, one of the chambers is in session right now. And they could more than likely vote on the conference committee report today. That will constitute passing the House. The Senate will likely do that tomorrow on Monday when they convene. And then it'll go to the governor. And then, of course, the governor will sign it and it will take effect on September 1st. So just because the bill has passed and just because it's been signed into law, it doesn't go into effect like all bills. Okay. They're not doing something special with this. All bills take effect on September 1st of the year in which the laws are signed into law. The bills are signed into law. So September 1st is the answer to that question.
For me, are we able to switch this to over here so I can move this over here to do the questions? So
okay, I'm gonna move some stuff around here. I've got to move. Hey, I'm gonna stop my screen for a minute because wait, what?
Move the camera over here so I can put this so I can see the questions.
Oh,
sorry, y'all.
All right, there's that. Okay, so section 3. Here we are, section 3, and this is the part that, at first glance, you might think, "Oh my gosh, what the heck?" This is where the police are allowed to tell us, are allowed to disarm us, and the Fourth Amendment violations and all that kind of stuff. First of all, let me tell you this: while I don't like this language at all, this language is exactly the same as language that's already codified. Okay, if you look in chapter 411.207, you look right here, and the authority of a peace officer to disarm, this language here is already in there. Okay, this is already the law. It's the exact same language. The only difference between what we're reading here in the conference report, right, that was added, that's new to the bill, the only difference between that and this and the current law is that it doesn't include anything about license holders. And so all the bill does in section 3 is it allows officers to do what they already can do to people who don't have a license to carry a gun. Now, I will say this. This is what I will tell you from a legal standpoint. Because here's what it says. A peace officer who is acting in the lawful discharge of the officer's official duties may disarm a person at any time the officer reasonably believes it is necessary for the protection of the person, officer, or other individual. The peace officer shall return the handgun to the person before discharging the person from the scene if the officer determines that the person is not a threat to the officer, person, or other individual, and if the person has not committed a violation that results in an arrest of the person. And what that essentially means, let me tell you what the intent behind that is, and then why I'm a little concerned even about the current law, but also the fact that this is codified in there. I think officers are going to look at this and think this is something new. A police officer can't just walk up to you and see that you're carrying a gun and disarm you and say, well, I believe, for my safety and yours, we're going to take this gun off you. He cannot do that. Okay. He cannot do that. The intent behind this is, let's say you've got a gun, right? And you're doing something, or you might be somewhere that you're not supposed to, or you're doing something that is probably going to get someone hurt or might get someone hurt. Or here's an even better situation. Let's say you're in a heated argument with someone on the street or downtown. And, a police officer comes out there, he sees this heated argument, and he's concerned because he sees two people who are armed really going at each other. And he's concerned that one of them is about to start shooting. Under this law, that's the kind of situation that these types of provisions are designed to help with. Okay. That's not how they're always implemented, as you and I both know, because cops come up and the first thing they think they can do is just disarm you. And that's not what the law says they can do under Terry v. Ohio. That's not what the law says under any other common law from the Supreme Court. It's got to be a reasonable. Now, see, here's that reasonable belief word again, that it's necessary. Okay. Not just because it makes him feel better. Now, a lot of people don't know how to argue that, but regardless of what this says here, a police officer cannot simply just disarm you unless he's got a reasonable belief that you are a danger to yourself, the officer, or other individuals. An officer can't just have a blanket, well, I stop. And this is the best thing that can happen in court, is when you get to court, the officers, and if I were a defense attorney, one of the first questions I would ask that officer is, officer, why did you disarm this guy? I mean, you were just going up to talk to him. Well, I disarm everybody if I know they have a gun. Just for my safety. Okay. That right there tells you that what he's doing is unconstitutional, because that's not a reasonable belief. 100% of the people you come in contact with will not give you a reasonable belief. So with that said, I don't want people worrying about Section 3, because Section 3 is literally word for word, verbatim, what is already in law for the license carriers. And this just creates the same ability of law enforcement for unlicensed carriers. You have a question?
Well, he keeps piping up about how the way it's worded, that's what's going to happen. And I think CJ has already addressed that that's what they're...
It's not worded. Yeah. Like I said, it's not worded.
Cops are going to be cops. And yes, they're probably going to be like, oh, we have the power now, but that's not.
Yeah. Tyrants are going to be tyrants no matter what. Yeah. And
we got it. We hear you.
Bullies are going to be bullies no matter what. But what I'm saying is this wasn't specifically worded any differently than what's already in law.
I have a few questions.
All right.
So if the weapon taken temporarily is a long gun, but since a long gun is not a handgun, he doesn't have to return it at the end of a stop.
Yeah. He does, because current law already... This is, again, long arms aren't touched on this. So there's already law about authority of a peace officer to disarm under 411-207. Now, I know that's talking about, again, a handgun, but the rifles are the exact same way. Officers, it's a violation of due process if an officer comes up and he takes your rifle, whether it's codified or not. It's a violation of due process for an officer to come up and take your rifle, pistol, anything, and you haven't committed a crime.
I think what you just said answers this next question about, so what do you think is going to happen in this situation? Do you really think a citizen is going to say no? That's already been happening. And
what people need to understand is what the law is. And what the law, if you can articulate to a police officer that, when he goes and says, okay, well, look, for your safety and mine, I'm going to disarm that. Whoa. So, no, officer, I do not consent to that. First of all, do you believe I'm some kind of a danger to you? Well, you've got a gun. That's not what the law says. And you need to be able to repeat those words. Your officer, it says, you can only disarm me if you have a reasonable belief that I'm a danger to you, me, or people around me. You're just here asking me questions. You are not allowed under law nor under case law to disarm me just because it makes you feel better. That's not what the law is designed to do, to make you feel better, although that's why a lot of these amendments got added, because help law enforcement feel better. And so it's up to each individual person to determine how they're going to handle that. And different people are going to handle that differently. I'll tell you, I'm one of those guys that I'm going to argue. I'm not going to let someone just, well, you guys have seen it. I'm not going to let someone just disarm me. No way. It's just not going to happen. But you've got to know how to argue that.
And then someone else brings up that this is just coded to have them run the numbers through that type of language.
And that's another thing. If they're running your numbers, I think there's an argument for an unconstitutional search and seizure. There's no reason for them to be running your numbers on your rifle. All right, let's get into Section 4. All Section 4 does is this is the expungement section. And so once this becomes law in September, it used to be that if you were convicted of an offense of unlawful carry, which is 4602A, if you were convicted of an offense of unlawful carry prior to September 1st of 2021, you can request under the current law, Article 5501, to have your records expunged. Okay. So let's say right now, you were doing nothing else wrong. Maybe it was maybe you were speeding, a police officer pulled you over, maybe you were jaywalking, whatever, for whatever reason, you were stopped. And the only reason that you got a 4602 unlawful carry charge was just because you were carrying unlawfully, not that you were using the gun in a crime. Okay. If you were using the firearm in a crime, that's different. But if the sole purpose of the conviction is that you were convicted for not having a license, right? But you weren't hurting anybody, then you can have, after September 1st, you can have that conviction expunged under the law. That's what Section 4 does. That's a good thing. All right. That's a good thing. I like that. I like that section. All right. And then there's just more of the same stuff there. Let's go to Section 5. Let me catch up on my notes here on the table. 1, 2, 3, 4, 5, and then 6. All right. So actually, I don't think there was much under Section 6 or Section 5. This was just, just adding. All this does is it just adds that expungement stuff. All right. Section 6 is, you're going to see a lot of these sections. All it does is it gets rid of 46035 and, it just sticks to Section 4603. And what this bill has done is it's completely repealed 46035, and it's going to recodify all of that stuff into Section 4603. And so a lot of the reason this bill is so long is because of little things like this, where they're just striking out 46.035. So let's go down to Section 7. This is nothing big. It's just this was an amendment that was also added. The liberals thought that they think they're going to get a win on this. And one of the reasons they wanted this amendment is because they wanted to study whether or not going to constitutional carry is going to result in more crimes relating to carrying of a firearm, right? And you're going to have more criminals carrying all that. So what Section 7 does, it just requires DPS to every year compile a list of information about the license, like how many people apply for a license to carry. And they want to contrast that from now until 2028. If we go down here, from now until 2028, DPS is going to collect all this information about licensing. And by February 1st, they have to release a report that explains whether or not going to constitutional carry has resulted in more, less, or just as many people applying for licenses as was done the previous decade. And so that's all that is. It's no big deal. It also includes a section where DPS is going to develop and post on their website free courses, free of charge, courses on firearm safety and handling. And of course, I don't believe in government mandated training, but everybody that's got a gun should be trained. Absolutely. Hang on. Let me go back over here to just bring that up there a little bit. Oh, nope. I want it to be bigger. There we go. Hopefully y'all can see that. If that's not big enough, let me know and I'll make it the big screen again. Okay, Section 8 talks about revocations. There's a little bit in here, and all they did, again, was get rid of this convicted of an offense under 46035, which was carrying by a license holder where, you're not supposed to carry by a license holder. So nothing huge in there. And then so because it striked that, it did a whole bunch of this renumbering here. And so that's just sort of cleanup type stuff. Section 9 is There we go. Section 9, nothing big there either. That's just getting rid of the 46035. Same with section 10, going to section 4603. We'll get to that in a minute. Section 11 was, I don't have any notes here. Same thing. Just a bunch of cleanup stuff. 14, a bunch of cleanup stuff. Oh, no, 14 was different. So 14 was, this is for foster parents. This is an important thing because, as you know, there have been judges and others who have said that, if you've got a gun in the home, you can't be a foster parent. Well, what this says here is, yes, you can. It used to be you had to have a license to be a foster parent and keep a gun. You had to be licensed. If you didn't have a license, but you had guns, which you could legally have, that you couldn't be a foster parent. Well, now, as long as you're not otherwise prohibited by law from carrying a handgun, then under this bill, you can be a foster parent. You don't have to have a license anymore. Okay, so that's another good thing that's in there. Section 15 was cleanup. Section 16, go down to the bottom here. So section 16 is just another, it's just a part of cleanup, but it added in air guns as well. That what cities cannot regulate, because they can't regulate firearms and stuff like that. So now what this does is it makes sure that cities aren't making these stupid rules that, because remember before, under the current law, as it is right now, a city can regulate the wearing of guns in city parks if you do not have a license. But if you do have a license, the law is very specific that preemption takes place. Okay. Well, this includes air guns under that preemption statute, and it includes unlicensed carry. So it's no longer just licensed people. So now cities and municipalities and governments cannot prohibit you from carrying a gun as long as you're not a prohibited person. Okay. All right. So there's that. That was pretty simple. Again, a good thing. We'll go to section 17 because everything else is just cleanup here. All right. Now, this is where things get a little weird. Okay. And this is where I think we're going to have possibly some problems. There are several interpretations that I can get out of section 17. And one of them is, what this does is it allows a business under a 30.5, which, 30.05 is just the standard criminal trespassing statute, but it allows, what are you doing?
I'm trying to find the mouse.
I've got the mouse.
Oh, and you did.
Oh, yeah, you can touch stuff there too. It allows a standard sign. If someone wants to ban guns, they can put up a 30.5 sign, and it doesn't apply to license holders. It just applies. And if you don't leave, which we're going to get into here in a little bit, you'll have a penalty. But we've got a question.
Someone said, "What about that suppressor bill? Is that coming up?"
Okay, I'm not talking about the suppressor bill today, but I will tell you that the suppressor bill is on its way to the governor.
Okay, under 18,
so that passed.
When you're talking about the air rifle, right? The air.
There is no law about carrying an air rifle under 18.
Okay, there you go.
So, all right, back to section 17 here. So there is a new sign requirement that if you don't want someone to carry firearms on your property, you have to put up this new sign pursuant to 30.5. A person may not enter this property with a firearm. That just is added into the criminal trespass code to also include, it's kind of stupid because it essentially creates one sign now. And we're going to have the same problem we had when open carry passed, where everyone's going to think they have to have all these signs, and you're going to see a 30.6 and a 30.7 and a 30.5. And these people are going to think they have to put all of them up there. And really what this means is all they've got to do is if they want to ban both, they just put up a 30.5 sign. Okay. That's what this is about. And then we'll talk about, it's got to be the same thing. It's got to be 1 inch in height. It's got to be in Spanish and English, and it's got to be displayed in a conspicuous manner, clearly visible to the public. And that's the big problem that we have. But this bill, what this bill is going to do a little bit later is it's going to adjust for that. And it's going to take into account for that because there's another section where as long as you leave when you're told, hey, look, we've got a sign right there, but you didn't see it, then you're good to go. It's no problem. And it's really only a Class C misdemeanor at that point unless you refuse to leave. But we're going to get to that in just a little bit. But that's what most of this section was about. And here's the offense. An offense under this section is a Class C misdemeanor, published by no more than a fine of $200 if you go onto the property and the only reason that you were denied entry or that you were told to leave was because they don't allow weapons. Like, obviously, if you're being rude, or if you're being disruptive to their business, or you're causing problems, because you're fighting with everybody, or you're screaming, or whatever it is, maybe you've got some vulgar shirts on, or something that they don't like, or maybe you're naked and they want you to wear clothes. If the only reason for them telling you to leave is that you have a gun and they don't allow for a gun to be there, if they come and tell you to leave, it's just a Class C misdemeanor if you leave. Okay. It's a Class A misdemeanor if you don't leave when they tell you to. Okay. So subsequently fail to depart. It's a Class A misdemeanor, and a Class A misdemeanor is up to a year in jail and I believe a $10,000 fine or something like that. So if you're told to leave, it's probably a good idea just to leave. That's what that is. I already talked about that. Okay, so Section 18 was just cleanup. Let me get back to my notes here.
On the trespassing, is a government entity allowed to trespass for carrying a firearm?
A government entity is not. They are not, unless they are one of those places that the law specifically says they can. Hang on one second. I think I got my sheet backwards. Oh, Section 18, Chapter 411. Okay, so this is 17 still. It's just really long, I think. Let me see where I'm at here. Subsequently failed to depart. Okay, yeah, I've already done all that. Oh, here's the other thing. Now, I said earlier that we've accomplished several things with this bill. This is one of them. One of the things we've been trying to get rid of is the word belt or shoulder as it relates to holster requirements in the law. So not only are you able to carry unlicensed, but now you could pretty much, as long as it's in a holster, you're good to go. It no longer has to be in a belt or shoulder holster. This has been one of the things that we've been trying to fix since open carry passed, and we've had bills that just didn't go anywhere. This bill, this is number 2 of the things that we've been trying to fix in the law. One of them was getting rid of the words belt or shoulder. So this bill does that. It gets rid of the words belt or shoulder. You only have to have it in a holster. Now, what does that mean for you? That means, for example, if you have like a cup holder holster in your car, or some kind of holster that mounts to your dashboard or something, and it's not specifically a belt or shoulder holster, you're fine under this law come September 1st, because it's just got to be in a holster if it's in your vehicle openly displayed. You have a question?
Are they going to still be allowed to carry at the Capitol without? Okay,
you'll still be able to carry at the Capitol. However, it most likely you will only be able to carry at the Capitol if you have a license. They're going to have to address that separately. It's not addressed in this legislation, but if I had my money on some kind of a wheel, it would be on the number that says you're going to have a license if you want to carry into the Capitol, because there are a bunch of scared ninnies up there, and they don't trust gun owners, and they barely trust license holders. I mean, Democrats, they already crap their pants at the fact that we get to walk around metal detectors if you've got a license. So I don't see that going away anytime soon, unfortunately.
If a firearm is in a holster, is it mostly concealed?
If you can see any part of the gun, any part, whether it's the tip of the front sight or a part of the magazine, it is considered to be openly carried and must be in a holster. If it's in a holster, it doesn't matter how much you can see of it. It doesn't matter, because as long as it's in a holster, you're free to have it concealed or open. There's still no requirement to have a concealed handgun in a holster. Okay, you can pretty much put that in your underwear if you want to. All right, so
someone sent you $2 instead of Class C misdemeanors on a free pass, CJ. And don't we know it?
Oh, I know that, Matt. Believe me, I'm not saying it's a free pass at all. And thank you for the $2, Matt. I appreciate that. And usually, what I'll do is I'll put that up for a few minutes. All right, Section 18 again, some cleanup. Let me get back to my notes here. 18 was cleanup, 19 was cleanup, 20 was cleanup, 21. So let's go down to 22. And again, when I say cleanup, it's just words like belt or shoulder and the 46.035 change. All right. Here's where, we had to give up a little bit, and we didn't, we didn't really get to do the 18-year-old thing. But Section 22 essentially makes it, an offense. I'm a little concerned about this section because they've removed this word and I don't think they realized what they were doing, because it essentially makes, the way I read this, I mean, no one's going to do this because it's dumb. Trust me when I explain it here, but you've got the semicolon here and they removed the word and it's kind of suggested. But it says a person commits an offense if the person intentionally, knowingly, or recklessly carries on or about his person a handgun. Okay, that the way I read this, that's one clause. The second clause is at the time of the offense. So if you're younger than 21 years of age, you've committed an offense. I mean, that's just being under 21 is the way I read this, because they got rid of the word and.
Sometimes we think of little kids under 21 offensive. So.
Well, yeah, but that's what kind of bothers me about this is it. But I think what they're intending this to mean, and I mean, obviously, who's going to come around and go, "Hey, how old are you? 19. Okay, you're under arrest under 4602, because you're under 21." I mean, obviously, they're not going to do that, but I don't understand why they got rid of the word "and" here, because it really does, or could, if somebody really wanted to be a prick, I think there's an argument there and it would have to go through the courts, but it's neither here nor there. But anyway, so you commit offense if you're carrying a handgun without a license and you're under 21, or in the last 5 years, you've been convicted of one of these offenses. I'm going to explain each of these individually. So 2201A1, that's just regular assault. 2205 is deadly conduct. 2207 is a terroristic threat. 4201A7, that's under the disorderly conduct. A7 is where you discharge a firearm in public, okay, recklessly, essentially, not in self-defense. And then, of course, 4201A8 is carrying a firearm in a manner calculated to cause alarm. So these are additional misdemeanor offenses in addition to being a felon prohibition. If you are convicted of any of these, assault, deadly conduct, terroristic threats, discharge of a firearm in public, or carrying in a manner calculated to cause alarm in the previous 5 years, you are considered ineligible to carry with or without a license. Okay. You have a question?
Yes. Okay. First someone says, where'd it go? There was a change to 30.6.
There was no change to 30.06.
And then someone says, so CJ, say a cop pulls up and sees you carrying, are we supposed to give up ID?
No, you don't have to give up ID.
Okay. That was just
the only time you have to ID in Texas, this bill doesn't change that, is if you are lawfully arrested. That's the only time you have to identify. If anytime you're required to, the only time you're required to identify is if you're required to identify, for example, you get pulled over for a traffic citation, or some other infraction in which they've got to write you a ticket. If you've got a license to carry, you are also supposed to, at that point, show them your license to carry as well. All right. But there is no requirement to ID under 1927. So unfortunately, it's 21 years of age. Look, we can keep fighting that. We're going to keep fighting that. You can't buy a handgun if you're not 21 anyway. It's a minor. It's an infringement. Don't get me wrong here. Okay. I am not here to tell you what my opinion is. I'm here to tell you what the law is telling you. Okay. Wait, you said a change in 30.6? I don't have a change in 30.6. Now, in a little bit, they're going to recodify some stuff by getting rid of belt or shoulder holster. I don't know what you're talking about. Well, all this does, all section 30.6 does is get rid of 46035. That's what I said. It's just a cleanup. It has 30.6 and 30.7 are exactly the same. Nothing changes except they changed what the code is that where you can find the meaning of the term license holder. So there's no changes to 30.6 or 30.7. I don't know where that's coming from.
And these two just popped up. Convicted felons can still have weapons at home.
So convicted felons can still have weapons at home after 5 years of their last adjudication. So if you've got a 10-year probation, that 5-year clock doesn't start until the end of that 10-year probation. If your entire sentence was jail time and you've served your jail time, your 5 years starts when you get out of jail, and you can keep it in your home. Now, keep in mind, that's state law. Okay, that's state law. The feds could still try and get you under federal law. And if a prosecutor wanted to be a prick and charged you for something else, he could charge you under federal law as well. So if you're a felon after 5 years, you can carry without a license on your property, and it's not an offense under state law, but it is an offense under federal law.
Okay, and he still says 3.6 has a wording change. It said below what you were talking about. I don't know what he's talking about.
30.6 has a wording change. It said below what you were talking about earlier. I'm looking at the only place where 30.6 is amended, right here. And 30.6 is only amended to get rid of the words belt or shoulder and to get rid of 46035. So section 16.
And this one says, but a rifle is okay. I'd rather face a man with a gun than a rifle. I'm not sure what he's referencing to you.
Okay, don't worry about that. If they're just making comments, I'm going to keep going.
Well, hold on. So this bill mirrors 30.6 and 30.7 with a few variants.
Yes.
Okay, and
again, 30.6 and 30.7 are not changed. Nothing changes about that. They still have to have those signs if they want to keep license holders out. The only difference is under 30.5, if they just want to ban guns completely, technically all they would need is the 30.5 sign instead of a 30.6 and 30.7. So I don't understand why they did that. I don't understand why they didn't just put the unlicensed possession under 30.6 and under 30.7. But I think that's something we might have to go in and fix later. But it really simplifies it for businesses. I'm not a big fan of, to be honest with you, I'm not a big fan of all these big signs that they have. I think if a business wants to keep guns out of their business, they should just be able to put up a sign. Now, the legislature and the NRA are fighting that they want this big, long thing because they think if they have this big, complicated signage that fewer people will put it up. But that's not the case in other states. And so I think we've created this 30.5 thing, which 30.5 will serve. Let me make this very clear. 30.5 will, if you see a 30.5 sign, okay, let me get back to that. If you see a 30.5 sign, it counts as you cannot carry in that place, okay? And it's right here. It's like a gun buster sign. If you see something that says pursuant to section 30.05 penal code criminal trespass, a person may not enter this property with a firearm. A person. It doesn't matter if you're licensed or not. Okay. Now here's the fun part. If you don't have a license and the business only has 30.6 and 30.7 signs up, or one or the other, then if you don't have a license, those signs don't apply to you because 30.6 and 30.7 only apply to handgun license holders. But if you see a 30.5 sign, that applies to everyone, whether you've got a license or not. That's why I said they made this very confusing, because it doesn't make any sense that, these businesses that spend all this money on 30.6 and 30.7 signs are now going to take down their 30.6 or 7 signs and have to put up a 30.5 sign if they want to ban all guns. Or they're just going to think, oh, I've got a 30.6, 30.7 sign, I'm good. Yeah, you're good for license holders,
let's let him think that.
But you're not good for unlicensed holders. Okay, is that clear as mud? Is that kind of show you how kind of weird our lawmakers are? All right, so we went over section 22 here. I explained that's a 21 year thing. Oh, I want to bring this up too. I wrote a note about this down here. So the section down here says the handgun is in plain view unless the person is 21 years of age or older. And this is talking about it being an offense. So the way that car carry works now, okay, so under current law, as it is right now today, if you're under 21, you can legally have a handgun concealed in your vehicle without a license. You don't have to be 21 under current law. So my daughter, who's not 21, can have a gun in her vehicle, and it's fine as long as it's concealed. Well, with this law, what this changes is, okay, well, now if you've got the gun open in your car, you have to be 21 to openly carry the handgun in your car.
Okay, wait. We have some questions on the signage.
Okay, we're going back to the signage.
Before we go, okay. And I think this is easy. This one's easy. Maybe I'm overthinking, but does anything change if a business has all three signs up? Yes.
If a business has all three signs up, really the only one that matters is 30.5.
Yeah.
Because 30.5 covers the other two. So if they have all three signs up, all they're doing is wasting time in retail space.
Okay. Do the signs have to be on all entrances or
Yes.
just one?
Signs have to be on all entrances.
Okay.
If you go in through an entrance that does not have a sign, you are not breaking the law. Good?
Yep.
Okay. All right. So I hope I made this part clear because this drives me nuts. This is the law today is in your vehicle, you can have a concealed handgun without a license. If you have a license, you can be carrying it openly on or about your person in a vehicle. Under the new law that will take effect September 1st, if you have a handgun in the vehicle and you are under 21 years of age, it must be concealed. Must. If you are in a vehicle and you are 21 years of age or older, whether you have a license or not, you can have it open, but you've got to be 21. Okay. That is stupid. It's dumb. I don't know why they did that, but they did. All right. So if you're 21 and older in a car, whether you have a license or not, you can open carry in a car. But if you're under 21, it cannot be open. Now I'm talking about handguns, not rifles. Okay. All right. Moving on.
Hold on. Type the questions if you guys have them.
What happened?
About the car.
Yeah, if you got questions about what I just said about the car, by all means. Hey, Cy, do you have a question? Let me see here. Real quick. Cy, did you have a question?
No, I'm just listening.
Okay, all right. I'm going to take you back out then.
Do these laws only apply in one state or all states?
This is Texas law. This is just Texas law that we're talking about here. So, all right. I brought that up. Let's see. I wanted to bring that. Got it. And then we need to go to section 23, I believe. All right, let's go down here a little bit more. Get my cursor back. All right, y'all hanging in with me? Are you learning a lot? I hope so. Okay. Let me go back here. Where are we in the code? We are still in section 4602. So I hate when it's sort of up here like this. So we're talking about a person commits an offense if the person is not doing these certain things. If the person is okay, so if a person carries or commits an offense, if they carry a handgun and intentionally display the handgun in plain view, except that it's in a holster. I think what they're doing is they're just moving this over into this other section. Okay, so just make sure if you're openly carrying a handgun that it's in a holster. That's all that this really says right here. I'm not sure why they added in there. Maybe it's just for extra spice.
I have 2 magnetic mounts for my pistols. They'll be legally used for open carry vehicle, right?
So there's no definition of what holster means in a car or anything. The law still requires a quote holster. If you can argue that the magnetic thing is holding your gun, I guess it would be a holster. I would think that would qualify. The problem is it's going to be a legal argument. I'm going to give you a legal answer, and the legal answer is it depends. And what does it depend on? It depends on the officer at the scene. And it depends on how well you can argue whether or not something is a holster. Okay. The magnetic mounts are going to be just as controversial or undefined as, the drop leg holsters were as a belt holster. As long as you can argue or articulate to somebody that the magnetic mount is a holster, which I think you could. If you have a good attorney, you could for sure. You could make that argument, but I can't tell you yes or no because the word holster is not defined in the law. But at least I can tell you this much. at least under the new law, having a magnetic holster under your dashboard. And you know what? Don't call it a mount anymore. Just get around. Just stop calling it a mount. It's a magnetic holster. That's all you've got to put is say, and you know, it'll help you. You'll be less likely to get in trouble. Let's just put it that way.
So that answered the question about the leg holster between the seat holster that straps between your legs. So this question says, does this apply only to Texas residents or any person in Texas?
Any person in Texas.
And I mean, you already answered this.
Oh, somebody give me $10?
Yeah, we'll get that.
Oh, Constitution under attack. Thank you for the $5, sir. I appreciate that.
That was answered earlier.
And then I've got a $10 one here. Oh, Zafarius. Thank you, sir.
We already put that up there.
Oh, did we put that one up there?
Yeah.
Oh, okay. I'm sorry.
You answered that already in the stream.
Yes.
So.
Yeah. So no, the words belt and shoulder are gone. Okay. So there's that. Now here's the intoxicated thing. I was talking to my wife about this because this kind of cracks me up a little bit. I mean, this just shows you, look, oh, you know what I didn't do at the beginning? I also didn't recognize the people who made this possible in the legislature. Matt Schaefer went to bat for you and he went to bat for me. Matt Schaefer made sure he fought tooth and nail at the legislature in that conference committee to make sure that we got the best open or the best unlicensed carry bill we could possibly get that was going to pass, that was going to get voted on. Okay. He fought to the death. Matt Schaefer, I would ask each and every one of you, okay? I don't care if you like politicians or not, okay? And I know we shouldn't be thanking politicians for removing barriers to unconstitutional laws to begin with, but you know what? This is the system we live in. And you know what? If greasing some wheels will get them to do more good in the future, then what's the harm in doing that, right? So give Matt Schaefer especially, and really all the people on this list, I mean, that were a part of doing this. Brian Hughes, Birdwell, Campbell, Crichton, Matt Schaefer. You've got so many. And then not only that, but Representative Guillen is a Democrat that was a part of this as well. And so there were a lot of people that really made this possible. But especially Matt Schaefer and Senator Shortner, please take some time to just send them a thank you. You know, just, hey, thank you for all your hard work on getting HB 1927 to where we are today. And I'm telling you right now, 99% chance we're going to have constitutional carry. It's going to pass. Okay. It's inevitable at this point, in my opinion. And so it doesn't hurt to make them feel better about themselves, and maybe they'll do more good in the future. Okay. But I'll continue to hold them accountable when they don't. All right. So a person commits an offense. This is continuing on here. If the person is intoxicated and not on their own property, inside of or directly en route to a motor vehicle or watercraft. So this is what cracks me up, right? It's an offense if you're drunk in public and you've got a gun, unless you're in your vehicle and you're drunk. So you can't be charged with unlawful carry, but you can be charged with drinking and driving or operating, driving under the influence or operating a vehicle under the influence. So I just thought that part was funny. I wanted to bring that up because it says that, you know, if you're intoxicated and you're carrying a gun, it's an offense unless you're on your own property or someone else's property with their consent, or inside of or directly en route to a motor vehicle or watercraft. So I personally think that's funny. I read this as an attorney. I'm like, oh, good. Okay. So you can be drunk in your vehicle now with a gun. Yeah, but just don't drive the vehicle. And actually, if you're in your vehicle and you're drunk and your keys are anywhere nearby, you can also be charged with DUI. So, all right. And then, so that's really what all of that stuff is. It's the same thing there.
And yes, we did answer the question about stop and ID.
Yes. And I'll answer that again. There is no stop and ID in Texas. Okay. If you are a person who is prohibited from carrying a firearm under the law, it's no longer just a Class A misdemeanor. What this law does is it makes you unlawfully carrying where is it? I just had the dang thing. It's a felony, but there it is. An offense under the section is a felony of the second degree with a minimum term of imprisonment of 5 years. So if you're a prohibited person, and the reason they did this was because they wanted to make sure, you know, obviously there were all these arguments from the liberals. oh my gosh, if we get rid of the licensing, everyone's
Oh
going
my
to carry,
gosh,
and
you sound like your dad.
felons are going to be carrying, and we're just, it's going to be the Wild West, pimp style around here. And so what they wanted to do was make sure that it's a really serious crime if you're carrying a firearm and you're a prohibited person. They wanted to make it a more serious crime for so-called prohibited persons from being able to carry. So under 4604A, which I brought this up for you here. Under 4604A, it's a, what is it again? It's a second degree felony, right? Yeah, second degree felony. 4604A talks about schools, 51% establishments, correctional facilities, hospitals, amusement parks. Although I think amusement park was stricken later in this bill. I can't remember, but we'll get to that in a minute. I remember that being addressed. Or on a civil commitment facility. Okay, so if, oh wait, that was B. Sorry guys, hang on. It's a second degree felony. That's under A. Let me go back up to A.
Strike that. Forget
Strike
everything you just
it.
said that.
Where's 4604A? Here we go.
About that. Anybody in Texas, does that mean people who are here on green cards or work?
If you are a legal citizen of Texas, green card or not, you can carry. As long as you're here legally, you can. And I would argue, actually, the law doesn't say one way or the other. I think the federal law says you have to be a citizen, but there's no Texas law that requires you to be a citizen. You just have to be a person. And so even illegal immigrants, and look, and I'll tell you this, every person in the world has the right to keep and bear arms. Everyone. It's just their governments don't allow it. So even illegal immigrants have a right to keep and bear arms. Some of y'all might not like me saying that, but I said it anyway.
Are college university campuses still able to carry a gun? I don't think that changed. Right?
No, that didn't change, but you have to have a license to carry on a campus. All right. Let's go down to, all right. So I'd said that if you carry illegally, it's a felony. And depending on which, depending on what kind of a felon you are, it can be a second or third degree felony. And then we move into, okay, so now we're going to go into section 23. And this is where I'm not going to spend a lot of time on section 23 because all section 23 does, you remember how this whole time we were crossing out 46.035 because it said 4603. Well, under 4603, all it did was take all that verbiage that was in 46035 and it put it here in 4603. Okay. So it got rid of it and then it put it here. So I'm not going to go into this. All of this stuff is already the law right now. This doesn't change any of it, but I think this is where, nope, the amusement park is still in there. Okay. I couldn't remember if it was in there or not. So that is exactly the same. 46035 still exists, but it exists under 4603. Okay. So I'm going to skip this section because it doesn't change anything. It just moves wording around to different places. Yes.
So if you are a prohibited person, how will they know if they don't impose some sort of stop and ID? I'm just asking because I have my permit and carry everywhere and don't want to be harassed by OEL.
If you are a prohibited person, the way they're going to know is you're committing some other crime. They have no right. There is already, now there's not case law in the Fifth Circuit, which is what Texas is in, but several circuit courts have already decided. The Supreme Court hasn't weighed in on this issue yet, but 3 other circuit courts have already decided that open carry or carry where legal does not justify a stop and ID. Okay. Now it's not what they call controlling law in Texas, but it's what we can call persuasive law in Texas. So if you refuse to ID because, an officer's like, hey, how do I know if you're a prohibited person or not unless I ID you? Then, that's a violation of your rights because the default status cannot be that you're a felon in possession or that you're a felon or that you're a prohibited person. The default status is that you're a law-abiding citizen unless you're doing something else. And I'll tell you this right now, if a police officer wants to know, they're just going to follow you long enough until you do something stupid, like your tire touches the lines as you're driving down the road. Oh, crossing white lines, pull you over. You've got a light out on your license plate. You didn't use your blinker. You didn't come to a complete stop. They'll find some reason to stop an ID you to find out if you're a prohibited person. But look, I'm going to be blunt. And law enforcement, if you're out there listening, look, this is the case law. You cannot stop somebody just to determine if they're a prohibited person. You just can't do it. You cannot do it. Now, will you? Yeah, you probably will, but prepare to get sued. Prepare to get sued, because I know a guy who's going to be suing people like you one day. Just saying. All right. Section 24, just it really just says if you're a member of a criminal street gang, which is defined under a completely separate section, you can't be carrying a gun in your vehicle. So if you're in a street gang, no drive-bys. All right. Section 25 is a cleanup. And then section 26. This is what I like about section 26. Let me get to it here. Like I said, 25 is just a cleanup. What is this here? Wait, let me get back to my notes. Let me see if I had any notes under this section. This is just the 4603 signage, I think. Oh, wait, no. Defense to prosecution. Okay, so, here we go. So under the law, under 4603, okay, and these are prohibited places. If you carry a gun onto the premises or other property that's prohibited, and someone comes and tells you, hey, no guns, you can't have guns here, and you promptly depart. You're like, oh, okay, I'm sorry, I didn't see the sign, or I didn't know, and you promptly leave. Okay, that's what's called a defense to prosecution. Now, I want to explain something for those of you that don't know. There's something called an exception, and there's something called a defense. If it's an exception, they can't arrest you for it. Okay, if you meet that exception, they cannot arrest you for it. But when the law says something like this, where it says it is a defense to prosecution, that means you can be arrested for it, and your attorney has to bring up what's called an affirmative defense. This is called an affirmative defense. Has to bring this up as an affirmative defense. That, look, my client is not guilty because, under section 4603, he was told to leave and he promptly departed the premises. And at that point, the judge would have no choice, because you would do you would have a motion for summary judgment, and that's your defense. You've proven it. You'd have to prove it, and then you're done. Is it really? No. That's an hour ahead. I haven't changed that clock yet. All right. So anyway, that's what this section is about. Now, here's the other thing, though, right? That doesn't apply if there is a sign posted. This was a question earlier. There's a sign posted prominently at each entrance, and you knew that carrying a firearm was there, but you were going to be like, I'm just going to pretend I didn't see it. Okay. It is your duty as a gun owner to look and see if where you're going is now you don't have to search the entire building. It's supposed to be prominently displayed at every single entrance. And I'm going to be honest with you. I've gone to places where one of the entrances didn't have a sign. And so I went in that entrance in case something happened. I'm like, look, I came in that entrance. It's a defense to prosecution. I didn't know there were signs up because when I came in, there was no sign on the door. It wasn't prominently displayed. But if you knew that and it was prominently displayed, now this is what's called mens rea right here. Okay. They're going to have to prove that you knew that carrying a firearm was prohibited. I don't know how they're going to prove that, but that's called mens rea. They're going to have to prove mens rea on that. But just so you know, don't play the game. Just don't go and play the game. This is the same thing about the language. It's got to be conspicuous. It says 4603. It's got to be 1 inch in height, all that kind of stuff, yada, yada, yada. Okay. Did you have a question?
Yeah.
Okay, we got a question.
Okay, 72. Wait, so it's up here. What about a 72-year-old who was incarcerated in 1970? He wants to know if he can carry.
A 72-year-old who was incarcerated in 1970, if it was a felony, can still not carry under federal law unless he's gotten a pardon. But he can carry or keep a gun in his home or on his private property and in his private business after 5 years, which obviously 1970 was more than 5 years ago.
And we've already said this, so just kind of go over it really fast. What kind of sign is required for prohibiting?
Oh.
Prohibiting.
30.7?
No, right here. Prohibiting carrying an establishment. Same signage.
Okay.
And the additional 30.5. 30.5. Right?
Yes. Now, what this is doing here, what this section does here is, you know how sometimes you'll go to a courthouse, and a courthouse under 4603, under Penal Code 4603, they don't need to post signage because it's already a prohibited place and people are supposed to know that's a prohibited place. However, since there's not going to be any training that's required or mandated by the government, and you know, people should find out the law themselves. If you're going to carry a gun, it's on you to know what the law is, and that's kind of what Open Carry Texas is here to do. But there's a 4603 sign, and all that is, you've already seen them before. You go to a courthouse, they've got a sign saying that pursuant to 4603, you know, you can't carry a weapon on this property. So what this is doing is this is putting the weight of the law behind those signs now. But it has to, for example, if you go to the tax collector's office and it's just a tax collector's office and they put up a 4603 sign that says under section 4603, a person cannot carry a firearm on this property, that's an illegal sign. Okay. But if there's a legal sign, like it's a courthouse or it's a hospital or someplace that's already, well, not a hospital because they have to put up 30.6 or 7 signs. But if it's already a government building, like a jail where guns are prohibited, they can put up a 4603 sign as well. And 4603 is just the statute that says all the places where you can't carry a gun. Usually it's government facilities. And the signs, for the signs to be good, like HEB is terrible at this. The signs have to be in contrasting colors, which means that the background has to contrast with the letters of the sign. What HEB likes to do is do like a what's the
white on clear.
The velvet, not velvet. What's that material they use? The
Vinyl.
They use the vinyl lettering cutouts and they stick it on the window, and you can't see because there's no contrasting colors. So it's got to be at least 1-inch letters, and it's got to be in contrasting colors. Okay, block letters, can't be in cursive or any special anything like that either. All right, so that's what all this was about. And then here we go. So this is the end. Section 26. This is another. So I said this is the third thing that we got accomplished this session that is contained in this bill. 3 of the things that we have been fighting for a long time are contained in this bill. Unlicensed carry, getting rid of the words belt or shoulder so that it's only a holster. There's no longer a limiting holster requirement. And the third thing is get the TABC out of the gun business. That's what Section 26 does. Section 26 gets rid of all of these sections here, and I can go through them if you want, but I'm not going to. Really what that means is, you know how when you go to Walmart and you see that big blue sign that's a felony, the unlicensed possession of a firearm on this premises is a felony. And that's because they have an alcohol license, but it's for off-premises consumption. They sell alcohol, but you can't drink it in Walmart. You can't drink it in Target. You can't drink it at the gas station. Those signs are no longer required. Those sections are repealed. And therefore, you don't have to worry as of September 1st, if you don't have a license, it is no longer a felony to walk into a Walmart without a license, as long as you're not a prohibited person, or a gas station or any place that sells alcohol. And that's pretty much it. Here's the last part, Section 29. This act takes effect September 1st, 2021. So don't think you can go around if the House passes this tonight, the Senate passes it tomorrow, or vice versa, whichever one is in play right now. If they pass this tonight and it gets sent to the governor, and then tomorrow the Senate or the House signs it, and then it gets sent to the governor on Tuesday, and the governor signs it on Wednesday, it doesn't mean on Wednesday we have constitutional carry. All bills, except for a very small fraction of bills, go into effect on September 1st. If you remember, the open carry law didn't go into effect until January 1st of the following year because they wanted more time. We fought that this year. We didn't want, that was stupid. There's no reason for it. Okay. There's no difference here. There's nothing to prepare for in the law here that we have to wait till January. It's just on September 1st, you don't need a license anymore. That's the bill. That's 1927. I think personally it's a good bill. I think that Schaefer did a really good job, and Schwartner did a really good job advocating for us and making sure that that we were able to get this. And let me also say this, Speaker Phelan. This wouldn't be possible if Speaker Phelan didn't put James White as the chair of the relevant committee. This wouldn't be possible if Dan Patrick didn't create that special committee, which I was really worried about. A lot of people were really worried about it. But you know what? I didn't attack Dan Patrick for these decisions. I know some other gun rights advocates did, because they were like, oh, what kind of games are they playing? I was always suspicious, but you know what? I gave him the benefit of the doubt. So Dan Patrick creating that special committee, sending the bills straight there, putting strong members inside that Senate committee is why we have, or we are going to have, constitutional carry in Texas this year. If you want to look up the,
Yeah, someone's asking if there's a link.
I'm going to give you guys the link right now. Actually, I think it's on this side. Hang on a second. I'm on two computers here. Copy image location. There we go. All right. Let me go back to my chat. Here is the link to read the bill for yourself. I think. Oh, wait. No, never mind. That's not it. Don't listen to that. Ignore that. Ignore that. There it is. Sorry. Ignore that link. That's just to the, you're just going to get a little icon if you do that. All right, here we go. If you would like to read the bill, this is where you go to read the bill. I know that's a lot. You can probably take off that hashtag navpanes equals 0 and just go to the PDF, and you'll get the PDF of this. The other thing that this does, let me look over here just so I can see where I'm at here. Actually, I'm just going to go back to this. The other thing that this does is at the end of the bill that's on the link right now below, if you go and you download this, towards the end, there's what's called the conference committee report, and it's a section by section analysis. And what it does is it tells, and this is what I want to go through with you now, because I just went through with you what the bill is. This is what they're going to vote on tonight and tomorrow. What it doesn't tell you is what was taken out of the bill. And this is what was taken out of the bill. Obviously, the codification of the Terry doctrine was removed. So there was a section 10 was removed that said a peace officer may not make an investigatory stop or other temporary detention to inquire as to a person's possession of a handgun solely because the person, I don't know what it is about certain people in the Senate that they simply do not like the Rinaldi Huffines amendment, which is really what that is. And it doesn't matter the fact that this section is not in the bill. We need to put it in the bill because some officers, they're stupid. A lot of them, and they think they have power that they don't have. And I guarantee you, they think they're going to have the power because of the way some of this other stuff is written to stop and ID you or stop and check your weapon and all that kind of stuff. Look, ladies and gentlemen, they do not. So that part was taken out. That's why you didn't hear me talk about whether or not, that special wording that was added in the House about them being able to, it specifically said, no, officers, you cannot stop someone just because they're carrying a gun unless you have some reasonable suspicion. What's up? What are you doing?
It's not a clothespin.
No, it's not a clothespin. It's a bullet.
He ain't that ghetto. It's
a bullet. You just take a drill through the middle of an expended cartridge. There you go. So that's gone, but the common law of Terry v. Ohio still applies. Okay. You're going to hear some cops saying, oh no, because I heard this after open carry. I heard this and with my own ears from officers. Oh no, well, that section of the law was taken out. Yeah, well, it was taken out because it was already law. And, but that's not really why they wanted to do it. They wanted that plausible deniability because police, if it's not written in stone, then they'll just try to get away with whatever they want to get away with. And unfortunately, we have too many legislators who want cops to have more power than they really do. So that's one of the things that was taken out of the bill that I don't like. But again, it's already law. It's already law, so we don't have anything to worry about there. The other thing, the 30.5 signage is new. They took out some language about, another defense, but again, that was nothing big. The intoxication part was added. That wasn't a part of the House bill. But really, the only thing they took out of the House bill was that one section. Yeah, was that one section. So there you have it. And then they just added, the 4603 signage. All right. That is 1927 in a nutshell. That's the whole bill. What does it mean? Bottom line is you can carry without a license on September 1st as long as you're not a prohibited person. That includes all felonies and some misdemeanors. So that includes domestic violence as well as assault. And for the last 5 years, assault. So that's a 5-year bar. Terroristic threats is a 5-year bar. Deadly conduct is a 5-year bar. Carrying in a manner calculated to cause alarm is a 5-year bar. And negligent discharge of a firearm in public is a 5-year bar. Other than that, if you can legally own and possess a firearm, you can carry it under this law as long as you're 21. That's the thing that is done. All right. Any other questions? Has the bill banning new federal laws passed yet? Not that I'm aware of. Not that I'm aware of. How long before you pass the bar? It'll be next summer. I finished my last semester next year. I graduate in May. I'm going to be taking my MPRE test this summer to get it over with. And then I just have to pass the bar next summer. States where constitutional carry has been in place has worked out fine. Yes, it has. Okay. I think we're done. I'm not going to make this too much longer because I want people to watch this video and actually get something out of it. Again, the link is right here below us. If you want to go and download that yourself. Another thing you can do if you just go to Legis, never mind, capital with an O, capital.texas.gov, and you type in HB 1927. Actually, you know what? I'm going to do this here. Let me open up my screen again.
What kind of are you going to be working for prosecution or defense?
I'm going to be mostly a defense attorney.
Okay, and that's only for the state, right?
Yes, for the state, but I'll also be doing some federal stuff.
Cool, man. Go get it.
All right. Hang on. Now, what I'm going to show you all really quick here is if you want to go and find this bill, type in capital because you're on. There we go. Yeah.
Where?
Just type it in. I can see it on my side. It's already come up. So capital.texas.gov. Once you do that, you'll come to this page. Let me make it a little bigger here. Oh, that didn't work. There we go. So on this, right here in this box right here, just click bill number, type in HB 1927. Hit go. You'll get a whole list of stuff over here. Go to text. You click text at the top of the thing, and you scroll down. This is the if you want to look at the bill as it was introduced, the House committee report when it was engrossed in the House, the Senate committee report, this conference committee report right here. This is where you will find what we just read. So you just click on this, and that's how you'll be able to find what we just read. You can also go and look at like witness lists if you want to see who was against it and who was for it. There's Mr. Briscoe, my buddy John Bolgiano, a lot of good people here. Rachel Malone, Tara Mika from the NRA. You might see your name on here. Registering for it but not testifying. a lot of people here I know as well. That's good to hear. And then keep going. Then you got against. So of course you've got the mad mommies here.
Just to say, he already talked about the 30.5 signs a while ago. He's talked about it a couple times in there, about what a pain they are. So I know he didn't breeze right over it by the time maybe you came into the conversation, but
I've talked about the 30.5 signs to, I mean, gosh, I don't know how many times I don't know how I breezed over it.
Also, someone said if someone is prohibited by Texas law, but they have a different state's license to carry that is less restrictive.
If you have another license to carry from another state, then you're good. I mean, when I was banned after my case, I went and got an out-of-state license so that I could keep carrying in Texas. And it doesn't matter that I'm not that I can't legally carry on a Texas license. As long as you've got a reciprocal license with Texas, you're able to carry on an out-of-state license. It doesn't matter if they're more strict or less strict. But anyway, you can see who all voted, and John Lott was here. That was a really good discussion. But anyway, that's how you go and look at the bill. I hope that helps everybody. So it's capital.texas.gov.
Any other gun laws that passed this session?
The only other one I'm aware of right now is the suppressor bill has passed and is on its way to the governor right now. And essentially what that bill does is a suppressor that is made and sold in Texas and bought in Texas is not subject to federal laws. Okay, because it does not engage in interstate commerce. So that bill it's 957, I believe, is the bill number. Beyond that, I'll be honest with you, I've been so engrossed in my studies this semester. Rick Briscoe would be the one to ask about what other laws have passed, but the two big ones that I'm aware of is the suppressor bill and now this one, which is about to pass. So it's going to pass. No doubt about it.
And also, if you came in late and you think your question didn't get answered, like if you feel like the signs weren't covered enough, then maybe you go back to the beginning.
Yeah, just go back and listen. I'm not going to rehash all that stuff.
Yeah, because some of these questions were asked a couple of times and were covered a couple of times, and he tried to make it short. This one to be short, so a lot of people could get in and hear it without listening to it for almost an hour and a half now.
Yeah, and remember, my goal here was to tell you what the bill says, not necessarily my opinion of it. My opinion of it is that I think we have a good bill. It's not great. It's not awesome. It's not amazing, but it's a good bill, I think. And we're going to continue to fight. Now we've gotten, look, when Open Carry Texas was founded, we needed licenses and we couldn't open carry. Now we can open carry and carry on a campus, and now we don't need licenses. We've accomplished all of our major goals. I don't even know what we're going to do anymore. But we are going to continue to fight for the little things. You know, we got to lower that age to 18 so that all adults are covered. We've got to get rid of some of these other little, gun-free zones and things like that. But these are all small things. We need to fix this bill to make it a little better than it is. So I don't know. That we're gonna meet and figure out what we're gonna do with Open Carry Texas. Most likely, one of the things we're gonna do is transition from like a 501c4 into a political action committee so that we can actually make a much bigger difference and start getting more actively involved in the political process that we can't do right now. And if things get bad again, we'll go back to being, I don't want to get rid of the 501c4 because we're still going to have to go around educating the public about what this law means, what you can and can't do, and all that kind of stuff. So
and chances are every time there's a new law passed like this, where the law changes, more organizations like the LEO organizations are going to need more education on what they can and can't do. And I mean, it's going to be up to them to step up. It's going to be more on them because they're the ones that are going to be doing the missteps, I guess you could say, usually when Open Carry passed with the permit when it passed a couple years ago. So that's probably what the role of OCT is going to be come September and once he's done with law school.
All right, y'all. I'm going to end this before I get to, hang on, I got one private chat here. Just make sure. Oh, yeah. Yeah, very true, Sai. I just saw your private message there. All right. I'm going to let this go. You guys take care, be safe, be free. And I hope that this helped a lot of you. Matt, thank you again. I appreciate. Hey, I've carried an AR pistol to the Capitol before. I've carried it several times. I've got a video where they tried to kick me out because they thought I was carrying a rifle. And
Jim, you know, if you were here, I would choose Molly.
She's sexier to look at, Jim. So, all right, y'all, take care, be safe, be free. I'll see you next time.